Thank you for joining me. My name is LaSheena Williams, and I am a Maryland family law attorney. My firm helps our clients take control of out-of-control domestic situations. Today, we will be discussing joint property statements in your Maryland divorce. A joint property statement is an assertion that you and your spouse makes to the court regarding assets and liabilities in your marriage. Typically, you will file a joint property statement if there is a dispute regarding property in your marriage. The purpose of the joint property statement is to give the judge an understanding of what the key assets are, how those assets are valued, what liabilities are tied to those assets, and what the current title of those assets are. Defining the title or the named owner for an asset is key on your joint property statement. You and your spouse may have a different assertion regarding who is actually on the title. However, the title is who is the named owner. For example, you and your spouse may both have an interest in a house, but only one partner may be on the title. Or you and your partner may have an interest in a retirement account, but that retirement account is through your spouse's employment. The title for that retirement account will belong to your partner, although both of you have an interest. It is important to define the value of your assets. Depending on what type of assets you have in your marriage will impact how you value those assets. Some assets may be better valued using an appraisal. Other assets may be better valued using some sort of online reporting system. For example, if you want to determine the value of your car, you may want to check Kelley Blue Book. Very often, at the end of a marriage, it's very hard to agree on almost anything. Specifically, it's hard to agree on the value of certain assets, especially if one partner cares more about that asset than the other partner. You're not required to value your assets the same on your joint property statement. So even if your partner is certain that a certain asset has no value or very high value, your assertion for the value stands. If you and your spouse are not in agreement regarding the value or title of your asset, then it's your obligation to prove to the court that the value or title you're asserting is accurate. If you have a deed, that would corroborate. If you have a car title, that would corroborate. If you have an appraisal, that will also corroborate. You must provide proof to show that your standpoint or assertion is accurate. If you have any questions about joint property statements in your divorce or any other family-related issues, please feel free to subscribe to my YouTube channel for future updates. Please also feel free to give me a call at 301-778-9950 to speak with an attorney today.